Welcome back, and I'm covering the Florida Territorial slave laws. This is part two. Part one covered the first 22 sections, and I was reminded of a story of these people that they're fighting for everything that they have. They're fighting for their very own lives because they really don't have a choice. And reading through this, I was reminded of a story. Back in 1980, I went to high school in Israel and was over there for several months. We studied a lot of the history, and when we were uh, studying the Holocaust, went to Yad Vashem, talked to several of the Holocaust survivors. There was a number of them still alive back then. I don't know if there's very many of them left now, over 40 years after when I was over there. But our teacher asked us, now we have the nation of Israel, a safe place for Jewish people to live. Uh, the world's advanced. Why do we still study the Holocaust and about the discrimination, the pogroms, and I guess every nation culture has their period of history where they're in a life or death struggle. Uh, Even for the Black Seminoles, this was a dark period in history for them that they were fighting to survive as well. And our teacher asked us this question, why study the Holocaust if the world's gotten better, hopefully, since then, since World War II? Uh, you have the nation of Israel, a safe haven for the Jewish people. And why still rehash it and go back to it? And, we gave several ideas for a few minutes. And then one of the students speaks up and says, because it could happen again. And the teacher said, "Yep, that's it. Class over." We were kind of stunned at that point because our classes usually didn't end abruptly like that when we got to the point. And but they were right. I mean, we're studying these laws because history and society could go back to those dark times, and you could face discrimination and legal discrimination all over again, where people are not allowed to get together in free assembly, that they can't even buy and sell things at the flea market or wherever without written permission, that anything they could do would result in them getting flogged 39 or lashings. So we're at that point that we have to remember the discrimination that's going on, that's happened before, and that if we don't fight for the freedom of ourselves and everyone, then it could happen again. Okay, let's go to the public acts, the laws of Florida from 1839, although most of these laws were written from about 1828 to 1834. Let's start here on the left, section 23, page 221. And I'm going to summarize all these things. I'm not going to read it verbatim because we'll be here forever. Section 23 says all runaway slaves may be apprehended by anyone to be taken to a judge, where they will be jailed and sent to their master. The person who captured the slave shall be paid $5 if it is over 5 miles from the slave's residence or owners. So that gives anybody the power to apprehend a slave and take them before the judge. Doesn't matter who they are, and it doesn't seem like there's very much evidence they need to prove to say the person was a slave. Section 24, a runaway slave may be placed in any county jail of the territory, and the sheriff shall advertise the capture in the local newspaper up to 6 months. If the owner does not claim the slave within 6 months, the slave shall be put up for public auction and sold. So anybody can find a Black person, claim they're a slave, take him to the judge, and the person will be imprisoned. And there's I guess, a classified or a newspaper ad put in saying, runaway slave found. If nobody claims them within 6 months, they'll be put up for auction and sold. So even if a free man of color and protests and claims that he's really free, but they don't believe him, they'll put him in jail. And after 6 months in jail, nobody claimed him. He will be put up for auction. So it's almost a guarantee that if you're a free man of color, nobody's going to believe you. You can be jailed and put up for auction. Section 25, excuse me. An owner of an apprehended slave will need to provide proof of ownership, providing the clerk or justice certificate of ownership and pay expenses incurred in the apprehension. The jailer, sheriff, or other officer may deliver the slave to the owner without proof if they know the person aren't satisfied that the slave belongs to them. So there's like an exception in the clause. If you claim to be the owner, you have to show your license or certificate, which I mentioned in the first part here. But if the jailer or sheriff knows you, they can just take your word for it, even without proof, and hand the person over to you. Page 222, section 26. If the slaves are found to be lying out and hiding by individual or group, the justice of the peace may issue warrants for their arrest and authorize a patrol to apprehend them. A reward of $10 for each slave apprehended shall be issued. So it's basically authorizing a local posse or a military militia unit to hunt for the escaped slaves with a bounty paid on each one captured. Section 27, if any owner or of a ferry or toll bridge allows a slave to cross without a pass from their owner or master, then the owner of the ferry or toll bridge will be charged $50 payable to the justice of the peace to be paid to the aggrieved owner or master. So if you operate a ferry or a toll booth, you are not allowed to let a slave pass who doesn't have a pass from their owner, or you'll be fined for $50. That's equivalent to $1,500 or such in today's dollars. So that's quite a fine. Section 28. The Indian agent who takes a runaway slave may demand $10 from the owner, of which $5 will go to the individual who apprehended the slave, and the other $5 paid to the Indian agent to be used for building jails, procuring irons for confinement, and for better securing runaway slaves. The agent may also require the owner or overseer 25 cents a day for the daily subsistence of the slave in confinement. So, pay have the owner pay for room and board. And of course, half the $10 demanded from the owner would go to the person who apprehended it. Section 29, the Indian agent shall make an annual report to the governor. So this is the governor of the Florida Territory, of the amount received for runaway slaves and how the money was applied. So that's the audit or paperwork for the apprehending of the slaves by the Indian agent. And we know in Florida Seminole War history, you had James Gadsden and William Duval alternately acting as Indian agent. You had Gad Humphreys for a number of years. You had Fagan, can't remember his first name offhand, who was there for a short time and then removed. And then you had Wiley Thompson, who became Indian agent and was killed by Osceola 2 years after that. Page 223, section 30, it shall be the duty of the Indian agent to advertise all runaway slaves in their custody, and that the overseer, the owner, overseer, or employer shall pay the usual expense charged for the advertisement. So if you're an Indian agent and you apprehend somebody you think's a slave, and you can charge $10 to the owner when they come to claim it, but you also include charging an advertisement to say who you captured, put in the local newspaper. Section 31, no cruel and unusual punishment shall be inflicted on a slave within the territory by any master, overseer, employer, and any who shall authorize to permit such punishment shall be fined according to the magnitude of the offense at the discretion of the court, up to $500 to be paid to the treasury of the territory for use of the literary fund. That's kind of strange. Okay, $500. Let's multiply that times 30. So that's $15,000 if you're inflicting cruel and unusual punishment on a slave. That's kind of subjective. I would think that a lot of these offenses include 39 lashings or nailing your ears to a post. I mean, how much crueler can you get? That's pretty cruel. Well, you know, it itself, I guess that's not even cruel enough to meet the criteria of this section. And then the fine shall go to the literary fund. So it'll basically pay for the schools. You know, that's kind of ironic. Yes, this is really messed up. Section 32, if any person possesses of the life estate of any slave or slaves, shall remove or permit to be carried out of the territory, slaves or their children, without consent of the state holder, shall forfeit the slaves or the value to the original owner. It's a little confusing. It has to do with removing slaves before the estate holder has passed away. So if you have power of attorney and take the slaves out of the territory, by law, you're supposed to forfeit them up to the owner. Section 33, any woman owning slaves, if she marries and her husband removes her slaves from the territory, she can sue to have her slaves returned for full the full value of them. That's interesting. Section 34, any slave or slaves who conspire to rebel or make insurrection or plot to conspire to murder any free white person shall be put to death. Section 35, if any slave or slaves who shall commit assault and bribery with intent to kill a white person, they shall be tried, convicted, and put to death. These are felony offenses, and basically, if a slave commits a felony, they shall be put to death. Section 36, any slave, free or Negro or mulatto, who shall attempt to kill any person by poisoning, when they shall be adjudged guilty of felony, they shall be put to death. Notice that this one doesn't apply just to slaves, but any person of color, slave or free, if you're convicted of plotting to kill somebody, you're put to death. Page 224. Oh, went too far. Oh, okay. Section 37. Any new Negro or mulatto slave who shall be convicted of any felony not punishable by death shall be whipped not exceeding 100 lashes by the proper officer of the court. So I guess 100 lashes is not cruel and unusual punishment. That's pretty harsh, I'd say. Section 38. If any slave shall maim a free white person, or attempt to commit any capital offense, or be guilty of manslaughter, or guilty of burning any dwelling house, store, cotton house, gin, or outhouse, barn, or stable, or shall be accessory thereto, each such slave shall be convicted, suffer death, or being whipped not exceeding 39 stripes, and have his or her ears nailed to a post for 1 hour, or shall have his or her hands burnt with a heated iron in an open court. So you can, if you burn down the plantation, or like in Clinton's plantations when the Indians came and burned down the sugar house, if you're accessory to that, which some slaves were, you can either be put to death or you can be whipped, or you can have your ears nailed to a post, or they can take a branding iron and brand your hands in an open court. Section 39. Any Negro or mulatto who assaults a woman or child to commit rape, such Negro or mulatto shall be cropped, branded, or suffer death at the discretion of the court. Seems like a lot of these offenses, there's not much you have to do to prove the offense. There's nothing written in the laws here. Section 40, any slave who steals or carries away any goods or chattels being legally convicted before the justice of the chief, who's deemed guilty of larceny, the master, overseer, and the employer shall restore the goods to the owners. The slave shall receive up to 39 lashes, and the master, overseer, or employer will be charged the cost of prosecution. Section 41, any Negro or mulatto found guilty of giving false testimony or perjury shall have his or her ears nailed to a post for 1 hour and receive 39 lashes on their bare back. Section 42, anyone who has an interest in a slave, or, a conflict of interest is what this is, in a court case shall not serve as a jury on trial for such slave. So if you know the slave or the slave owner and you're a jury on trial, then you'll be dismissed as a juror, and because of conflict of interest. Section 43, last one on this page, any person who causes to be kept any slave on a plantation without having a white man, the person shall be convicted and fined $5 for each month. So you can't leave the slaves alone by themselves. This became a problem during the Seminole War because a lot of the plantation owners fled their plantations because of threats of being captured by the Seminoles. And at one point, they abandoned their slaves. I include that in my book, Alachua Ambush. Section 43, any person who causes to be kept any slave on a plantation without having a white man, the person shall be convicted and fined $5 for each month. Page 225. A body of men slaves not exceeding 7 in number without having a white person shall not travel, and if found, they may all be whipped, not exceeding 20 stripes each, without reference to the civil authority. So if you find a body of slaves exceeding 7 in number, anybody can capture and whip them without the approval of a judge. Section 45, a slave who shall barter, buy, sell, or deliver anything of value except brooms, baskets, or fabrics of straw, or rush without consent in writing from their master, owner, or overseer shall receive up to 39 stripes at the discretion of the judge, justice of the peace. So if you're a slave, you're not allowed to sell anything except implements that the slave would normally use, like brooms or baskets. Section 46, if a slave shall go at large without a written pass from their owner, master, or overseer, or shall fire hunt, or keep a horse, boat, or canoe, such slaves shall be punished by stripes not exceeding 39 at the discretion of the judge. So that means a slave cannot go anywhere without a written pass. They shall not fire hunt, and that's something like hunting at night, hunting with a lighter knot on fire, or fire hunting can also be fishing at night. Slaves are not allowed to keep horses, not allowed to own boats or canoes. Section 47, if any slave shall use, carry, or keep firearms, ammunitions, or weapons, except by special license from their master, owner, or overseer, for the purpose of killing game or any other lawful person that shall be issued weekly, such slave without a license shall be punished by stripes up to 39 at the discretion of a judge. And this is an amendment to a previous law. Slaves are allowed to use firearms for hunting with a license from their master. Section 48, it shall be not be lawful for any free Negro or mulatto to be brought into the territory from any other U.S. state or territory if any free Negro or mulatto shall migrate, be transported, or brought in the territory and remain 30 days. He or she will be liable to be arrested by any citizen, brought before a judge, mayor, or be dealt with agreeable to law, or the judge can issue a warrant for their arrest. So you can't be a free person of color and enter Florida. If you remain 30 days, you can be arrested and brought before a judge. And there's more to that. Section 49 on page 226. A justice of the peace or mayor whom the free Negro or mulatto is brought upon examination determines that the free Negro or mulatto has migrated, been transported, or brought into the territory and continues in contravention of this act, the free Negro or mulatto shall give one or more good securities a bond of $200 payable to the governor, stand at the next county court, and if they fail to do this, they'll be imprisoned. So if you're a free Negro or mulatto, you're arrested, you have to give a bond of $200. So $200 times 30, that's about $6,000 in today's money. Yeah, how many people have $6,000 in their pocket? Yeah, okay. Section 50, if the court determines that a free Negro or mulatto has migrated or brought into the territory and remained, they shall give securities or bonds of $500. And let's see, once again, about 30, that's like $15,000. If you're determined to be a free person of color that you came to the Florida on purpose, you have to provide a bond of $15,000. Yeah, like you have that in your pocket, you know. And the free Negro or mulatto shall depart the territory within 10 days and never return. Or the court may take the free Negro and mulatto without securities upon failure to pay. The sheriff or ministerial officers of the court may sell the free Negro or mulatto for 1 year to the highest bidder, and the sale shall pay for a bond or security for the judge of the county court. Of all the monies recovered, half shall go to the person prosecuting, and the other half, deducting expenses, go to the county treasury. So if you're a free Negro or mulatto and it's been determined that you came to Florida on purpose and you're arrested and this has been determined, you have to post a bond that's equivalent today of $15,000, and you have to leave Florida forever within 10 days. If you can't do that, you're put up for auction and sold, and you have to work for a whole year. Section 51, the above proceedings shall be repeated if such free Negro or mulatto shall be found within any county of the territory after the expiration of the time assigned by the court that should have departed from the territory. So if you had paid the bond or you know were sold in auction, if you're found in any other county after leaving, you'll have to be arrested and fined and post bond all over again, or put up for auction again. Section 52, this act shall not be considered as extending to free Negroes or mulattoes who are engaged under a contract of service on board any ship or vessel, which may be within the waters of the territory so long as they remain in actual employ or on board of said ship or vessel. So if you're a free Negro or mulatto and you're working on a ship or under contract, then that's okay. You have to stay under contract, or if you're on a ship, you have to stay on the ship. Page 227, section 53 was repealed in 1832. Section 54 If any Negro or slave shall conduct or advertise the murder of any such person, every such involved shall be punished with 100 stripes at the discretion of the jury. So any Negro, free or slave, who shall be accused of consulting for advising a murder or threatening any person, you get whipped up to 100 times. Section 55, if any slave shall willfully and maliciously shoot any free white person or wound any free white person in attempting to kill them, they shall be deemed guilty of a felony and be put to death. So you can't shoot at any white person. Section 56, if a Negro or slave is convicted of robbery or burglary, shall suffer death or have their ears nailed to a post for 1 hour and receive 39 lashes on their bare back at the discretion of the court. Section 57, the court shall appoint counsel to defend any slave where the master of the slave fails to or refuses to employ an attorney to defend such a slave. All such attorneys shall receive for their services from the master, owner, or guardian a sum that the court deems reasonable, not exceeding $50. So that today would be what, $1,500, and not much for that's not much for legal fees. So any slave on trial in a court, the owner or master has to provide an attorney. If they're not provide an attorney, a public defender will be appointed, and the owner or master will be charged for their services. Okay, section 58. If any slave is brought before the court as a witness of a trial, they'll be told to tell the truth. They'll also be told that if they are found to have lied or give false testimony, they'll receive up to 30 lashes upon their bare back and have their ears nailed to a post for 1 hour. Note that this section, it doesn't say that the slave is made to swear an oath, but just told that are informed that they will tell the truth and told what they do. No slave is made to put their hand on the Bible and raise their arm saying that they'll tell the truth. They are just informed that to tell them that they will do that or they will be severely punished. Section 59, slaves shall not own any horse, mare, gelding, mule, cattle, or sheep. If any slave is found with such, he'll be forfeited and sold by the justice of the peace, and half of the proceeds after deducting costs and charges will be paid into the county treasury and the other half to the person prosecuting. So no slaves are allowed to own any livestock. Page 228, section 60, almost through on this part. If a slave is tried in a superior court, the same rules and regulations shall be observed. They are now observed in the trial of free person. So a slave is given representation while you're in trial, but doesn't have to be a good lawyer, I suppose. Section 61. If any Negro or mulatto, bound or free, shall commit any other crimes or misdemeanors against the law of the territory, a jury shall convict them and they shall receive up to 100 stripes. So you can be a free person of color, or you can be a slave. Any other crime not mentioned herein, you can be whipped up to 100 times. Section 62, the master or owner of the slaves shall not be liable of any costs or charges by the court except mentioned herein. In the capital cases, the owner of a slave who is executed shall be entitled to the valuation of the slave as what the jury will determine, paid by the territorial treasury. So if you're a master owner and your slave is convicted and executed, the master can be paid the value of the slave by the territory treasury. Section 3, any Negro or free person of color shall not supply any prisoner in the jail with intoxicating liquors without the consent of the marshal, sheriff, or jail keeper. Punishment shall be up to 20 stripes at the discretion of the magistrate. So no person of color, free or slave, shall provide alcohol to any slave who's jailed. All this law was approved November 21st, 1828. And I'm going to stop here, and we'll cover more in part 3 and some other laws and acts in this. And so I'll cover a few more pages. And I hope you found this interesting and stick around for the next part.